Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Listen, I wanted to set this episode up because we are going to be talking about this very obscure, little known case that probably nobody has ever heard of involving a guy named Jeffrey Epstein and Ghislaine Maxwell. All right. Obviously, everybody in the whole world is talking about this case. So, of course, we have to talk about it too. But we're going to be talking about it through the lens of our expertise in sentencing, advocacy, and post conviction relief. So, of course, I'm going to have my good friend and colleague Mark Allenbaugh on with me. But there's a couple of things that I needed to do first. One is to let you know that when Mark and I get together, we're worse than two scamps in a sewing circle. And it's a long episode. So, we have cut it into two parts. You're about to hear part one. Please come back for part two. But of course, after we recorded this really great long conversation, the big news dropped that Ghislaine Maxwell started meeting with the government. And so we did not have an opportunity to talk about that, but I thought I would just give you my quick 2 cents here before we begin, because the truth of the matter is talking heads abound on every network, and most of them don't know what they're talking about. They've never experienced this stuff firsthand. So, one of the things the press is going crazy about is the fact that the government gave Ghislaine Maxwell, quote unquote, limited immunity when she went in to have these talks with them. Everybody's freaking out that how could they give this convicted sex offender, sex trafficker immunity? Well, relax. Relax, buddy. Okay, listen. This is standard operating procedure in federal court. It's common. These folks who are freaking out about this just don't understand the process. When you do a meeting like this, it's called a proffer or a queen for a day or a free talk. And all that means is they want her to be able to speak freely and truthfully about everything she knows. And you've all heard the Miranda warnings, right? Anything you say can and will be used against you in a court of law. Well, in a free talk, they turn that upside down and they say anything you say cannot be used against you in court directly. That's so they can speak freely and know that someday down the road they won't be back in court for new proceedings and they'll say, you admitted to this in our free talk, you admitted to that. And they can't do that. Okay. What they can use is something called derivative use of her statements. If this case ever ended up in court again, that's a whole other story. So, say she disclosed the fact that Epstein killed one of their victims, just hypothetically, and the government didn't know that, and she helped bury the body. Well, that statement, "I helped bury the body," cannot be used against her because it's direct use and she has limited immunity for that. Now, if she told them where the body was buried and they go and find the body and there's evidence that they find there that links her to this crime, they could use that evidence, even though the only reason they found the body was because she told them about it. They just couldn't use the statement from her that I participated in that crime. Got it? So that's the first thing I need you to know. This is standard operating procedure and no lawyer worth his salt, and make no bones about it, her lawyer, Mr. Marcus, is more than worth his salt. He's one of the finest criminal defense lawyers of our generation. He is never going to walk his client into a proffer session with the government without some sort of written agreement for limited immunity. So stop talking about it. It's a non issue. Relax. Relax, buddy. You know I'm referring to the great South Park episode that just dropped. Anyway, so that's the first thing I need you to know. Ready? Second one. Why is she doing this? What does she stand to gain, and what does the administration stand to gain? Nobody knows for sure. We can speculate until the cows come home. But here's what we do know. The administration has totally lost control of the narrative, and every day it spins further and further out of control. They are meeting with her to determine whether they can use her as a pawn to flip the script and change the narrative. And so, of course, they're going to want her to say that Trump is nowhere to be found in these files, has never been to Epstein Island, has never done anything untoward with minors, yada, yada, yada. They need her to exonerate him, full stop. And in the same breath, they probably would love it for her to implicate some of the other players in this drama, especially ones that are on the other end of the political spectrum to this administration. So they need her to help rewrite the story. And that's exactly what she's doing in that room. I guarantee it. I guarantee it. Now, the real question is going to be what is the cover up? Because the cover up is always worse than the crime. In other words, she can say whatever she wants in that room, but we know there are files out there. I don't know if there are client lists or what the evidence is, videos, but there was a substantial investigation done by the Department of Justice about Epstein, Maxwell, and all the people in their orbit. And so somewhere there is a mountain of evidence that shows us what the truth of the investigation revealed. And now they have an incentive to even further bury that evidence or even destroy that evidence and simply rely on the new narrative, allegedly new narrative, that Maxwell is going to spin in order to try to get a get out of jail free card. Can she get it? Can she get a pardon or otherwise get out of the 20-year sentence that she was given? And the answer is, I guess. Trump clearly has the legal authority to issue a pardon. It was a federal prosecution. Now, politically, it sounds like very treacherous waters to me, but you never know how that's going to play out. But here's the big question. I will bring you back to day one of the Trump administration and that slew of executive orders that he signed. Well, one of them was about President Biden's commutations. He did mass clemency, commutation, not clemency, of almost all of the inmates on federal death row, all but two. Remember that? And boy, was Trump pissed. And what did his order say? It directed the states to take a look at every one of those federal convictions that resulted in the death penalty and determine whether or not the states could now bring their own death penalty charges in state court against any of those that had their sentences, their death sentences, commuted. And so, why do I direct you back there? Well, because Ghislaine Maxwell has been convicted of very, very serious crimes. And where was she convicted? New York. Which means that if the state of New York wants to prosecute Ms. Maxwell for any crime she may have committed, they can do that, assuming there's no statute of limitations or some other unforeseen issues. But there's no double jeopardy between federal and state proceedings. So what's sauce for the goose is good for the gander here. So if Trump pardons her, there is nothing to say that the state of New York or any other state where she may have committed some of these offenses in could take up a state prosecution and re-prosecute her for any of those offenses. So that is going to be a very interesting question. So we don't know how far this pardon is going to get her, and we don't know how far it's going to get Trump, especially with the political blowback from an already pissed off MAGA base. So from where I'm sitting, Ms. Maxwell's best bet is to, I don't know, fake her own death and sneak her out in a laundry truck and get her ass back to France. She can live out her days as Gilly McIntosh and shack up with Roman Polanski. She still has her French citizenship. They can't extradite her. She can get a job as a, mild-mannered cheesemaker from the Rhine region. There's no guarantee that a pardon from Trump is going to save her from the ultimate fate of spending quite possibly the rest of her life in prison. And I guess my final note is here's what really blows my mind about this. I'm worried that the practical impact of this is lost on the general public. But can we just stop and think about this here? Because this is what blows my mind. 6 months ago, Todd Blanche was Mr. Trump's personal criminal defense lawyer. Now he's second in command at the Department of Justice, but guess what? He is still acting 1,000% in the capacity of Trump's personal criminal defense lawyer. Only this time he's doing it with all of the power and resources of the federal government behind him. What a dream for a defense lawyer to finally have unfettered power to do anything they want in service to their client. But the problem is, we are supposed to be Blanche's client. We, the people. Okay? The Department of Justice is supposed to work for us, the citizens of the United States. They're not supposed to be Trump's personal lawyers, and they're certainly not supposed to be engaged in a whitewash or a cover up to protect alleged sex crimes committed by the commander in chief. So this is, I'm sorry, fucked up on so many levels. So I need people to really understand what's happening there and really pay attention to it. And I guess the good news is there are some people, especially even MAGA people, who are looking at this and they are beginning to fully understand how fucked up this is. But anyway, we have a lot to talk about with Mark Allenbaugh. So enjoy, I guess enjoy. I don't know. I hope you get something out of it. But here's part one of Maxwell's Silver Hammer. Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hello, everybody. It's Doug Passon coming to you from Studio 3553. It's a lovely Sunday afternoon, and I am here again with my good friend and colleague, Mark Allenbaugh. So first, let me say hello, greetings. What's shaking?
How you doing, Doug?
I'm good. I'm good.
Good.
Here's the thing. I love listening to podcasts, which may be
Mm,
why I started a podcast. But that podcast I can't get enough of these days is Pivot. Do you listen to
pivot.
Pivot? It's with
No.
Kara Swisher and
Oh,
Scott Galloway. I don't know if you've
oh.
seen Scott Galloway, but he's really like brilliant guy and very, very interesting perspective on everything. But these two are so good together, and they always start by like a little banter, like, "What did you do this weekend? Where are you?" And he's
Mm.
always flying around like, "I'm in my house in Paris," and
Oh, jeez. Wow.
and then he starts telling his story about, "Oh, I was in Ibiza. I was in Ibiza, and I did ecstasy or I did Molly last night." The guy's like older than us. And I'm like, you're
Wow.
really like laying it out there with your personal life. And then I'm like, well, I think it's one of the most popular podcasts around right now. So maybe we're doing something wrong. We just usually jump right into the legal shit. And,
Oh, you talk about tequila for a little bit,
we
and
do talk
yeah.
about you never share any of the personal details of your life. But before you do, just so you know, and this is the other thing you were telling me, you need a sponsor for this podcast. Well,
Yes. Yeah.
in an ideal world, we'd have one, but I can still pretend. And today's sponsor is, and there's no thematic tie-in to this tequila that I'm about to pour, other than to say this is my all-time favorite brand of tequila in all of history that ever was and ever will be. This is the GOAT Fortaleza. And so I'm
Fortaleza.
Fortaleza, and I'm about to pour a little bit of the still strength Blanco. If you get your hands on this bottle, anybody, grab it. Don't look back. You will thank me. Anywho, who did you hear that? Cork came right
Oh,
up.
yeah.
Listen.
So-
Okay.
Ah.
So what's going on with you in the personal life? Wait, listen to this. I don't know if you can hear that. Anyway,
No, it's
I
too
was
too
doing like an
smooth.
ASMR, like with the porn,
Oh,
popping and
yeah,
wait, I'm
yeah.
gonna
Well,
whisper
not,
now. Now I'm about to drink some tequila. It's gonna be great. Okay, sorry. Yeah, no,
uh,
really.
yeah, they're really, geez, I don't know, nothing really big. Redoing our living room. That's about the biggest, most exciting thing right now. A new bike trail opened up around here that I've been using, and that's
Was that
uh,
like a road bike or a mountain bike?
I have like a hybrid.
Oh, okay.
Yeah, so that's what I use. But
That's
yeah,
cool.
that's
So
yeah,
Scott
that's
Galloway is doing Molly in Ibiza, and you're
yeah.
just
Well,
pedaling on your little
I'm just
hybrid on
pedaling
your new
around
bike.
and I
This
don't
is
know how
not
boring.
working. This is
It,
not working the way I
yeah,
intended
no.
it, man.
Yeah, you need a
But
more
you,
exciting
but
sidekick.
maybe we could do thematic because you could tell the listeners the house that you live in is like this giant old haunted house, basically. And I kind of feel like there were so many references. Oh, by the way, we're talking about the Epstein case today.
Oh
There were
yeah.
so many references to this house of horrors and all the, terrible things that went on. Not that that's happening in your house. Like there's no sex trafficking going on in that
I was like,
residence,
where's
but
this going?
I'm just saying, it's an old haunted house. I don't know.
Yeah, well, it's an old,
It's
it's
late, man.
215 years old, and we were told when we got it that it had been part of the Underground Railroad. So that was interesting that the fugitive slaves were housed here on their way to Canada. They were hidden here, I should say.
So are there like tunnels and stuff? Like have you found any secret passages?
I have found secret passages, and
What?
there's some really strange parts of this house. And it used to be, well, it's older than even the town that we live in. This town was
Wow.
founded like in 1853, and this house was built in 1815. So there's
Wow.
some, we're still learning stuff about the house, but there it's definitely haunted. I will say that there are some strange things that go on around here at night. And I don't
Really?
believe in ghosts. Oh yeah, I don't believe in ghosts or any of that stuff until we moved here.
What kind of strange things?
Well, just you
I
see stuff.
promise we'll get to Epstein in a minute, but
Yeah,
tell
well,
me.
yeah, you see stuff coming down the stairs. You hear little weird
What do you
bumps and
mean you see
stuff.
stuff coming down the stairs? Like apparitions?
Like apparitions, yes, like apparitions. And I have woken up more than a couple of times with something like floating right in front of my freaking face and scares the hell out of me. And, now everyone thinks I'm crazy, but it's the truth. I mean, this really
Yeah,
weird old
I would
house.
be out of that. I would be gone so fast. Isn't there a comedy routine? I don't remember if it was Richard Pryor or something, but like the Amityville Horror, as soon as the wall started bleeding, a
Yeah, well,
normal
we don't have
person would
that.
be like, "I'm out of here."
Yeah, so it's all pretty innocuous. Anyway, I have my trusted German Shepherd August, so he never freaks out. Although we do notice the cats will stare at the wall in weird places and things like that,
I
wondering
have
what they're
seen
staring
all
at.
of this in various horror movies, and I gotta tell you, man, never ends well. That's all I'm saying. So,
Yeah,
they all end up dead in the end.
yeah. We have a lot of
Or
Amish
one
Amish
person
around here.
ends up killing their whole family. I mean,
Oh, come on now.
that's the Amityville horror.
That is the Amityville
That's
horror.
every
Yeah, but
haunted house horror
yeah.
movie ever made, other
Well,
than The
no,
Exorcist. But she
or
just pushed a priest
Poltergeist.
down the step. Down.
Yeah, the Poltergeist is what I'm waiting for. Is that we're going to start finding that we're built on some old cemetery or something
Yeah.
like that, which I would not be
Right.
surprised. Yeah.
Right.
So
The interesting thing is though that because we all have like cable or streaming now, there's never that fuzz at the end of the broadcast day where Carol Ann gets sucked into
yeah,
the TV.
right,
So
right.
like the poltergeist would have to find another way to like suck one of your kids through into the
Alexa.
nether. Oh yeah.
Yeah, I
See,
just installed Alexa here, so it's
this movie is writing itself.
yep. Yes,
I
it is.
suppose we should probably get to the task at hand. And I
Yes, let's
guess
get to the task.
here's the
Yes.
thing. I think mentally I've been procrastinating, digging in because I don't know how we got to this point in life where we'd even still have to be talking about this case.
Yeah,
It
it is
just
very, yeah.
never goes away.
It
And so,
doesn't die. This is the case that does not die. Yeah.
yeah, so obviously we're talking about it because the whole world is talking about it, and so why not? Why not us, man?
Right.
But we also think that through the lens of our specialty, which is sentencing, that there's always a lot to learn about, what that aspect of these criminal proceedings. So we can't talk too much about Epstein's sentencing because he never made it to sentencing, at least the
Yeah.
second time. But we're definitely going to talk about plea agreements
Hmm.
because he signed a doozy whopper sweetheart, uh, probably the best deal I've ever seen in my 30 years of lawyering for someone who's accused of multiple
Oh
counts
yeah.
of what
Yeah.
he's done. And that plea is actually a character in the story of Ghislaine Maxwell because she's appealing all of her convictions, and a lot of it, maybe all of it, you tell me, is based on the plea that Epstein did back in Florida in, I don't know,
All of it. Yeah.
2007,
Hmm.
where she's trying to make a claim that because he pled guilty and there was a non-prosecution agreement, that she's somehow covered in that. So we're going
Right.
to talk about all of that, but before we do, I got to know, did he kill himself or was he murdered?
That's a really, I used to think people had to be just conspiracy. It was just the typical conspiracy theory to think that he was murdered. I mean, I used to think it was very obvious that he just killed himself. I mean, obviously he had all the motive in the world to do it. And, it's not uncommon for individuals to try to kill themselves or to have suicidal ideation, especially if they such a massive fall from grace, so to
Yeah,
speak. But
right.
then
Yeah.
what we discovered just this past week
Uh-huh.
was that there were first we discovered that there was 1 minute missing from the video. They had
Right. That's what we
cameras
were
outside of
told.
his cell.
Yeah.
Yeah, but this is what we were told for the first time. This was news. Just like 2 weeks ago, we were told that a minute, the same minute, is missing from the video every night because some kind of transfer of the tape or something like that. That was new, and it's like, why not fix that? So that's
Yeah.
very suspicious.
Right.
And now we find out this week that it wasn't a minute, it was three.
Yeah.
And there is some funny stuff going on with the tape that was very easy to determine
Yeah.
through metadata and all this stuff. So that raises,
Yeah. Well, they said
that seems really suspicious.
yes, it does. And I read from the digital forensic analysis that they posted around the criminal defense blogs that some of that metadata was that the tape was run through Adobe Premiere, which is editing software.
Right. Yeah.
So now that's what I use to edit my sentencing videos. I'm very familiar with this software, and I don't know if that is a smoking gun or not. It could be because, it what do you say, Occam's razor? Like the simplest explanation
Right.
is that why did they need to run it through professional editing software if they weren't making significant edits? Period.
Correct. Correct.
That
Exactly.
said, I will say this. I often get video in formats. Maybe it's a body cam or it's, police cruiser footage or it's an interview from the FBI, whatever it is. And sometimes the format, whatever proprietary format they use for this stuff, is
Yeah.
screwy. And a lot of times Adobe Premiere is like the magic bullet to encode that. And I often just load it in there hoping that I can play it, that it can read the video, and then I can export it into a more usable format. So it's not a slam dunk, but it certainly
Oh,
seems a
yeah.
little fishy.
It does seem fishy. Yeah.
A
That's,
little
yeah.
fishy.
Yeah.
Right. Now
So,
I don't know. I can, first of all, I'm going to say I could believe either scenario because, like you said, suicide is a thing.
yeah.
And, you're the stats guy. And I don't remember when we were talking about this, but you said as far as the Bureau of Prisons is concerned, that's like the number one cause of early death in
Yeah.
prison, isn't it?
Suicide. Yeah.
Yeah.
Yes.
People are ensnared in our system. It's a level of despair and trauma and hopelessness.
And there's no psychiatric care.
Right.
The most is the psychiatric care that does exist in the BOP is really just, we're trying to stop suicides. That's it.
Yeah.
They're addressing the symptom, not the cause.
Yeah.
They're not, there's insufficient
Yeah.
psychiatric care in the BOP.
and literally had a case. It was the Backpage case. In fact, I have a great guest coming up on the podcast, an amazing attorney, Joy Bertrand, and we talked about this in the Backpage case in
Mm,
Phoenix. I won't explain the case, but the argument from the prosecutors for them to take them into immediate custody at sentencing was that they didn't want anyone to try to kill themselves before they to escape their prison sentence. Because
jeez.
one of the co-defendants sadly had taken his own life on the eve of
Yeah.
trial.
Yeah.
And I thought to myself, well, doesn't that just tell you everything you need to know about our cruel and inhumane system that
Mm,
the even the prosecutors think that it's such an awful place to be in the Bureau of Prisons that
yeah.
a person of sound mind would rather end their life than expose himself to that. Now, Epstein wasn't in the BOP per se. It was a BOP, I think, run facility, but it was a pretrial. It's called MCC. And when you talk about no resources, no care, that place was the poster child for
Yeah.
the worst of the worst
Hmm.
kind of facilities. And, so he's in solitary confinement. It's this horrible place. And, I guess he's facing charges that would certainly land him in prison for the rest of his life. We know that those kinds of charges make you a target. So he's going to be
Yeah.
in target of violence and whatever. So I could see that he killed himself. On the other hand, it doesn't seem it doesn't seem to be in line with what we know about him and his history and the way he's sort of weaseled out of everything in his life.
Yeah.
Like these are the folks that are on the upper echelon who have unlimited resources, the very best lawyers in the world. Look at what happened to his first case. He got out with a relative slap on the wrist. Why
Yeah.
wouldn't and he think, yeah, we'll get out of like
Right.
hold on, just hold
Right.
on. It's gonna work
Right.
out.
Exactly.
Like it always does for me because I'm
Yeah.
fucking untouchable and
He may have
I
ended
have
up getting the indictment dismissed. That's the thing. So,
right.
he had every, given his track record of success and his resources, it wouldn't seem that somebody in his position would feel that they had no hope. He had a
Right.
shit ton of hope
Right.
and the resources to exploit that hope, whereas most
Absolutely.
don't.
Millions,
So,
he could spend millions of dollars on his defense. He's super
yep,
connected.
yep,
And, listen, this is my big beef with the pardon process as it currently stands, which is, I think, maybe my opinion, but it's if you have the cash and you have the
yeah,
connections,
yeah,
you are in a much better position to have all your charges go away.
yep,
And he had both of those things like more than any defendant probably we could ever imagine.
correct.
And you know what he also had? The little
Leverage.
a leverage in the federal system.
Leverage.
Well, he
Yeah,
had leverage because he has goods on very probably had the goods on important people, but he also has, the 5K. That's the currency of the cooperation.
yeah,
So
yeah,
there'd be a lot of people out there, and this is why I can't decide because there's a lot of people out there that don't want him to talk, period.
yep.
And it's never been higher up in terms of political, whatever. So could he have been murdered? Absolutely. I don't love conspiracy theories, but I don't think it's beyond the realm of possibility.
Yeah, it's not, it became more, I'll put it this way, it became less implausible over the last 2 weeks
Mhm.
based upon the new facts. I think still on balance, though, there's certainly a preponderance of the evidence that he did kill himself. But anyway,
Is
let's talk
three
about
minutes?
his.
I know, but let me ask you, is 3 minutes enough to murder somebody and hang them? I don't know. That I don't know. We need an expert, but go ahead. Let's,
Yeah, I think three minutes is certainly enough to render somebody unconscious.
okay. And then string them up.
And it wasn't like, from what I understand the facts. I mean, that all you need is somebody in there for 3 minutes is a long time to get somebody to go in there and kill somebody. You could
Yeah.
easily do it within 3 minutes.
Yeah. Yeah.
And,
And
they took quite some time to even find the body. I mean, he was left alone for a while.
yeah.
He may not. That doesn't mean he was actually dead within 3 minutes, but he could have been rendered unconscious on
Right.
his way to asphyxiation. So it's
Yeah.
not. it's not out of the realm of
Yeah,
possibility.
yeah. Well, and here's where we are and why this is
Yeah.
so still so in the zeitgeist every
Yes.
day, and it's not going
I'm
away.
glad you used that term. Nobody uses zeitgeist
Oh, I
anymore.
love that
It
term.
yes,
Um,
yeah.
it's not as beautiful a term as enigma.
Oh, jeez. Every day's a secret.
Every day's a secret. But anyway, this is the thing. I
Oh,
think now the majority of Americans know they're being lied to, but this administration has ostensibly too much to lose when the truth comes out because,
yeah.
everybody's way too close to it. So this is why we're talking about Ghislaine Ghislaine Maxwell today because she's kind of the linchpin. She becomes the centerpiece of the story. Her case is still alive, working its way through appeals. She's got the leverage,
Hmm.
and it's going to be super interesting to see what happens next. But let's rewind all the way
Yeah.
back to should we start with
Well,
the
let's start with his.
non-prosecution
Let's start with
agreement?
his.
Yeah.
Yeah. So it was
Take us
a,
back.
so it was a combination of a plea agreement and a non-prosecution agreement, and this was rather unusual. I'm just looking at it right now, and it's dated October 29th, 2007. And
And
what
this
was
is
in
in, tell us, this is in federal court in
no,
the,
it is well, it is
well,
yeah.
it's a origin is the federal prosecutor's office
It
in the
it
Southern
really what
District of Florida.
it was
Well,
signed by this
go ahead.
by it was signed by the U.S. Attorney in the Southern District of Florida,
Alex
but there was
Acosta,
Alex Acosta,
who went on to become Trump's
the labor say,
Secretary of Labor in
yep,
his first
yeah,
administration. But
and,
sorry,
and
go
now
ahead.
has disappeared. By the way, I
He
mean we know where
has?
he. Well,
Oh, he's just
he
off the
lives
grid.
down in he's off the grid. He lives down back in the Southern
He's
District of the
living in a
Miami area.
haunted house in
I was
Ohio.
wondering what he was doing, and so I looked him up the other day. I was like, what happened to him? He must be teaching somewhere. He's nowhere. I mean, he is just hunkered down. No social media, nothing, and not even like working at a law firm that I could tell. I thought for sure he'd end up at a dean of some smaller law school or something like that, but nothing. Anyway,
Wow.
so this there was no case in federal court, so this was agreement active federal case, which already makes it kind of unusual. There was, and there wasn't even an active. There may have been an active state case at the time, but basically, what it was a written agreement between the feds, the state, Florida, and Epstein. And what the agreement said is, in exchange for him pleading guilty to minor state charges,
Yeah.
prostitution, soliciting prostitution, the feds would not only not charge him, and they would drop any federal prosecution against him. And most importantly, let me read the language here that in consideration of Epstein's agreement to plead guilty and to provide compensation in the manner described above, if Epstein successfully fulfills all of the terms and conditions of this agreement, the United States also agrees, that's important, the United States, not the Southern District of Florida, the United
Mhm.
States,
Yeah.
also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to, names four women that were assistants and recruiters of Epstein who had various levels of culpability, which, by the way, none of whom have ever been prosecuted,
Yeah.
at least
So
criminally.
let's put a fine point on that.
Yeah.
Ghislaine Maxwell is not one of those four women.
No, and she is not named, but I don't think that's material because it says including but not limited to. So
Uh,
and the operative term is any potential co-conspirators of Epstein. See,
and,
she certainly is a and was at that time a potential co-conspirator of Epstein.
mm. By the way, I
And
just ran a little search on that non-prosecution agreement for
yeah,
United States. Comes up
yes,
38 times.
in this agreement,
Yeah.
Yeah.
38 times.
So, I mean, so let's cut to the
Why is that
chase.
relevant?
Okay, well, that's what we're gonna do. So here's her argument is, yeah, I'm not named in here, me, Ghislaine Maxwell. I'm not named in this, but as Alan Baugh just read, any potential co-conspirator. I'm certainly any potential co-conspirator of Epstein.
Mm-hmm.
Everyone argues that, I was his wingman, so to speak, or right hand person, and I
Right.
recruited and I did all these things and did it. So certainly I'm a
Yeah.
co-conspirator.
Yeah.
So I'm covered by that. Now, this was written down in the Southern District of Florida, and Doug, as you well know, generally plea agreements, when they're made, are made just specific to whatever district that the plea agreement is made in, whether it's Southern District of
Mm.
Florida, District of Arizona,
Yeah.
Northern District of
Yeah.
Ohio, wherever.
There's
So,
literally specific language in almost every plea I've ever
yeah,
seen that this agreement does not bind any other
correct,
United States district.
correct.
Yeah.
That is not in this agreement.
No, it's not.
That is not. So there's no limiting language to that effect. And furthermore, it references the United States, meaning the way the Maxwell interprets it, every single district within the United States, every U.S. attorney's office in the United States.
Right.
So her argument is, I was covered by this plea agreement. I was one of the potential co-conspirators of Epstein. The United States entered into this agreement. And I think further her argument is going to be, and I didn't read all of the briefing, but I think her argument, at least one of the arguments, the authority to bind anybody else. I detrimentally relied upon that. She could argue, and because I detrimentally relied, and he had the apparent authority, he appeared to have the authority. He was, the attorney for the Southern
Yeah.
District of Florida, so I figured he could bind every other district. Because he had that apparent authority, I can rely on this. And so therefore,
Sure.
I cannot be prosecuted
Right.
anywhere else, including the Southern District of New York, which did eventually prosecute me and convict me. All of that is invalid under this agreement. And so, did
So
she raise this?
go ahead, but I mean, you may when I first read this, I thought it was a stupid argument she's making, but after hearing you explain it like that,
Yeah,
it's a good argument.
it's a good argument. I think she's going to
You
lose. I think she's going to lose for a reason.
well,
I'll get there in a
yeah,
second. But
yeah.
it's a good argument.
I think I know where you're going, but
Yeah.
yeah, like because what the intent of the parties is clear in this agreement. No
Yes.
one's ever going to enter. No one. What if they thought Southern District of New York or somebody else can any one of these places could run with charges against him? Like no one's. I think they clearly relied upon that. So
Yeah.
what's the issue, especially when you love your Latin phrases, exclusio uno, expressio, whatever the hell that is. It's like
Oh, yeah.
if they didn't actually put in there this agreement doesn't bind any other district, then
Yeah.
you have every reason to believe
Right.
that it
And this is
does.
also right. And this, that this, as we stated at the beginning, this is an agreement unlike any other agreement that we've ever seen. So, I mean, the United States could not just say, well, look,
Yeah,
regular course of business. This is, we issue these
right.
routinely. This is what they always mean. No, I've
Sure.
never seen anything like this. No one has ever seen an agreement like this. And so, and even if there are other agreements like the point is they're
Never.
unicorns.
Yes.
Yeah.
And
And
why
so,
wouldn't they rely on, well, how would they know that this guy didn't have the authority to bind? It's a U.S.
right,
attorney. What do they
exactly.
know?
Right.
What they can't. And
Right.
by the way, we weren't ever supposed to see this agreement. Did you see that? That it was supposed to be
Right.
sealed. I don't know how it got unsealed. Eventually, it's all over the internet. We didn't do anything
Yeah.
silly, but
Right.
they wanted to hide this agreement from the
Right.
public.
Well, they want to hide it for other reasons
Yeah.
because
Yeah.
because Epstein had nothing to do with Maxwell. So, well, let's just address just the
Yeah.
procedural history here real quick. So we have this agreement. Maxwell says it covers her, and I think she has a good argument that it does.
Yeah.
She brings it up in front of the judge in the Southern District of New York, where she was prosecuted. He says, nope, this doesn't cover you. It cannot bind the Southern District of New York. Doesn't matter what they did down there. Fine.
Yeah.
Okay, so then she goes to trial. She's convicted. Now, then she appeals. She takes it up with the Second Circuit. Second Circuit says the same thing. And as a matter of fact, the other thing the Second Circuit cited, it was a rather short opinion. The Second Circuit stated that there was no evidence that the government was even aware of who Maxwell was at the time. First, I find that hard to believe as a
Hmm.
factual matter.
Right.
And second, even if that were true, I think that's irrelevant because of the language here. It says any potential co-conspirator. So it doesn't matter that the word potential obviously would encompass those that are not known to the parties at that particular time. But while that is, but that is a double-edged sword, and I'll get to in a second. That works for her and against her. So now, just to finish the procedural history, so goes up to Second Circuit. Second Circuit says no, this doesn't cover you, or at least it doesn't. It might cover you, but it doesn't preclude your prosecution. So now she brought this up to the Supreme Court, and she's petitioned for cert. Certiorari, which is just a review. She's asking the Supreme Court to review the Second Circuit decision. Now, what's interesting is when you petition for cert in front of the Supreme Court, not only do you have to have a really interesting and good issue, that's not enough for the court to grant review. You also have to establish that there is a split in the circuits. In other words, some circuits are going one way, other circuits are going another way, and you think that the court should take the case to resolve that split one way or the other, and hopefully in your favor.
Yeah.
And what she said, and I wasn't aware that this is a split, and I'm not sure, frankly, it really is. I haven't researched it all that much, and the government certainly doesn't think that there really is much of a circuit split there. But apparently, in some circuits, like the Ninth, where you're at, plea agreements can bind other districts. That you can enter into plea agreements that bind other districts, even if they're quiet about it. In other words, they don't specifically say that you enter into a plea agreement in the District of Arizona, and it doesn't say that it
Yeah.
necessarily binds the Southern District of
Right.
California, but it could still bind them even
Yeah.
in the absence. So there's some circuits that
Ostensibly,
go
that's why they include typically specific language in the plea that this plea is not meant to bind other
correct,
districts because they
and
want to head that argument off the pass. And if it wasn't a
that's the way,
legitimate argument, the government wouldn't be interested in putting the specific language in the plea to head it
right.
off.
And plea agreements are interpreted under principles of contract law, and that's always a good thing to do. Is we remove all ambiguities, but surprisingly, the government doesn't. It very often.
Okay, but isn't there
So that
another layer to this, which is the way the government and the defense frame the issue. The defense frames the issue of can you bind another district, but it
yeah,
seems like the way the government frames the issue is not just that, but also can you bind can you cover somebody who's an alleged co-conspirator who's not a
who's not a
party to
party
the
to it? Yeah,
litigate? Yeah.
yeah.
Like
So
if
that's
any
that's her
rando,
Achilles. Yeah, that's her Achilles heel. And so she's saying there's a circuit split. Some circuits go her way and say you can bind other districts. Others, like the second, say you can't. And so she's saying the second's wrong. Resolve the circuit split in my favor.
yeah,
So I
two
think there's
hurdles,
actually,
right?
yeah, there's two hurdles. I think I would say there's a fairly good chance that the Supreme Court will take this case. But I'd say if I had to put a percentage on it, I'd say there's 15 to 20% chance that the
Yeah.
court
That's a
will
low.
take this case.
I
Well,
like
actually,
that
I think
size.
that's high. To be
Oh,
honest,
is
I
it?
think that's high. I think that's a high percentage because usually a petition for cert has less than a 1% chance.
Why would they
So,
get involved in this though? Because it's such a rare, I mean, it's just such a rare
what
thing
I don't think
in the
it's well,
grand
I
scheme
think
of,
the issue is rare, but what's not rare, and why I think if they do, they're going to primarily grant it because it's important on principles of interpreting plea agreements. And I think that's where they could provide some clarity on what principles, should be applied. One of the big principles, that we apply to plea agreements is they're generally interpreted against the drafter. I mean, that's just that's a civil standard. So whoever drafts the contract, and if there's an ambiguity, it's going to be applied against whoever drafted that particular contract. Same thing here applies with respect to plea agreements. So they may take it just to get, grant some clarity and perhaps obviously to resolve this circuit split. If in fact, can a plea agreement bind other districts? If you're part of the Department of Justice, it's like you're one big law firm. So just like just like an associate or a partner can
Yeah.
bind a law firm depending on what they're
Yeah.
doing in a particular case,
Right.
you would think it would apply to the entire Department of Justice nationwide. So,
Well, and that's an easier pill for me to swallow than the other one, which is can it bind unnamed, not non-party
well, that's okay.
potential co-conspirators? I need my contracts professor to get on this
Right.
podcast.
But that's
Professor
that.
Greenfield, where are you? Because I need to know.
That's what I was referring to earlier in the double-edged sword. It's that
Yeah.
word potential. Well, that word potential, it gets her in and covers her. It also makes it very clear that the parties don't know who they're talking about when they say potentially. They might have intended to cover unknown people, but just for that same argument, because there's an unknown parties to an agreement that they knew nothing about, especially if this was
Yeah.
filed under seal. Maxwell didn't know anything about it at the time it was entered into. So she couldn't
Well,
lie.
that's an assumption.
Okay, that is an assumption. So I mean that, and
Yeah.
I think
I don't know.
ultimately,
Yeah.
yeah, but ultimately, I think that's what's going to. First of all, if the Supreme Court does not take cert, I can see somebody writing a statement in support of the denial of cert. We've been seeing a lot of those with this court over the last couple of years, by the way, all this commentary on when cert's granted or when it's not, dissents from denial of cert, or supporting the
Yeah.
denial of cert and stuff like that. But I could see somebody writing, like and Amy Berman Jackson, or what's her
Amy
name,
Coney Barrett.
Amy Coney Barrett, thank you, or even Justice Jackson writing something where, to the effect that, yeah, the reason why we didn't take this is there's too many factual issues.
Mm.
This is, and so that would be one of the factual issues about whether or not
No.
she was aware of this or something like that. But let's assume she wasn't, because that's what the government is arguing. And I don't recall her saying that. I don't recall seeing in the brief, which I didn't read very carefully, but I don't recall her saying that she actually detrimentally relied on this or was aware of it at the time it was executed. So this does come down to a contract issue, whether a third party can rely on a contract that they were completely unaware of and never relied on otherwise when it was executed or subsequently.
Yeah.
And I think that the answer is no. I'm pretty sure,
Yeah.
from
Well,
what I recall from contract.
it would be an easy call if the contract provision that somehow bound them was to their detriment. Like that would be an easy call. Like I didn't agree to pay this guy $10,000. I'm not part of this but
Yeah.
and maybe a harder argument if it's to their benefit, which is to say, of
Well,
course I would have wanted to be bound by
the
this.
district court's already, disagreed. The Second
Yeah.
Circuit's disagreed.
Well,
So,
I got to go back and read those opinions, but the truth is, if it's based on contract law, it'll go right over my head. I didn't do very well in that class.
so, but
Professor Greenfield,
so,
where
but
are
this brings
you?
up, a bigger issue, Doug, and I
Uh-oh.
think this is why I thought we
Well,
should
wait,
discuss
but
this.
wait a minute.
Yeah,
Before we move on to that, let's just
yeah.
say this is also an opportunity if you buy into the premise that the Supreme Court is now just the majority of the Supreme Court exists to do Donald Trump's bidding, then, they could just say, yeah, yeah, she's bound by that non-prosecution agreement, case dismissed, and then she goes off and never talks and disappears into the ether. And Donald Trump lives happily ever after if her case is dismissed. But that's a giant conspiracy theory, so we can put a pin in that.
Oh, you mean if they grant cert and
Yeah,
fine for her?
yeah, and her case goes away. And then that's a good way to solve this problem. It's better than 3 missing minutes of fucking jail footage, you know?
Yeah, but then Donald Trump loses all his leverage over her. Now she's free. She could talk.
Yeah,
as long
well,
as long as she's in, she's
it's
going to behave.
well,
Yeah,
I don't know.
that's just me and Donald
Now
Trump
we're into
think.
some gangster shit.
Well, that's Donald Trump. So,
Yeah.
you know, but so anyway, I think what this all shows is the importance of plea agreements, of well drafted plea agreements. And you and I have seen, unfortunately, we come into cases kind of late where plea agreements have already been entered into or about to be
Yes.
entered into.
Yes.
And there are some really badly drafted plea agreements that are going to work against
Yeah.
the client, again,
Yeah.
against the defendant here, or things that counsel hasn't thought of. So
Or just like not just inartful language, but just giving up the farm
yeah,
in
just
these.
get, yeah, and that's the big thing too, is what why what's the agreement just to begin with? Why do people enter into? Well, primarily it's because they are afraid of going to trial. It's not even so much that they're afraid of getting convicted. It's the fear of what we call the trial penalty,
Yeah.
that they'll end up doing a lot more time
Right.
if they go to trial and are convicted than if they plead guilty.
Right.
So
Right. This is about providing some certainty, some insurance that, yes, if I give up all my rights to go to trial and I take this plea, at least I have an expectation about how things are going to go.
yeah.
And
So I just have some.
if you operate from that premise, it really doesn't impact the whole way you approach plea agreement. By the way, I've said this before, but it's worth saying again. The reason we talk about plea agreements so much, even though we're sentencing specialists primarily, is because I always say there are two sentencings in every case. And the very first sentencing is the plea agreement. And that is because the government has so much discretion in what kind of plea to offer, what kind of charges to have
Yeah.
you plead to, what are the terms of the plea, what are the stipulations of the plea. And, you know, when you craft a favorable plea agreement, it can change the entire landscape of the sentencing that occurs
Yes.
however many months down the road. And that
Yeah.
means not only should you be talking to the government about, this enhancement or this amount of loss or this element or this factual basis of the crime, you should be talking to them about your client as a human being. This
Yeah.
is who you have, who you say is the worst person in the world or who has done this, that, and the other, but this is their life. And you need to know that you don't have the full picture. And they are worthy of whatever consideration you're asking for in this plea stage, in this plea process. And if you present, a lot of lawyers say, well, the mitigation, the story stuff, the life history stuff, that's just for sentencing, that's for later. And we say, no, no, it is not, because there are two sentencings, and this is your first crack at getting a really good result. And so
Right.
why wouldn't you put this on the table? But anyway, that's my preaching to the choir. I know you know this.
Yeah.
Go ahead.
So I mean, the first thing because that is the primary reason why individuals plead guilty. And by the way, over 97% of people who are indicted end up pleading guilty.
Yeah,
And that
everyone
and
does in this federal system.
yeah, well, and it's the ratio is very close to the same at the state level too, but it's primarily because of this trial penalty. But the thing that and I just published an article with Fred Hafetz about this in the New York Law Journal, that at least in white collar cases, the trial penalty isn't nearly as big as a lot of people think it is. And so in some cases it is big, and it all depends on the amount of fraud or the amount of physical harm that's occurred, the type of crime, and all this other stuff. But nonetheless, the point simply is, if once you get a client, don't just automatically think trials off the table. Maybe there's no triable issues and all that stuff, but nonetheless, I would not just dismiss trial out of hand before I know what is the likely trial penalty. And we have guidelines that you can calculate, and there's statistics available, and there's data available. And the trial penalty may not be as much as you think it is, and your client really deserves to know what that is
Yeah.
before, and you should know that too before you're advising whether or not just to dismiss trial out of hand and let's just go go to try to negotiate a plea. Because if the trial penalty turns out not to be that big, even if it means another year or two in prison, that may be something that your client is willing to risk for his or her right to go to trial and to try to prove that, or to put the government, really, I should say, to put the government to its test.
Yeah.
Because there's a lot of mistakes that could be made at trial,
Yeah.
a lot of appealable issues,
Yeah.
and there's a lot of ways to win other than through
Never
a
know
not
what
guilty
this
verdict.
witness is going to say or what that
Right,
witness is going to. You just
right,
never know.
right. So, and then you got to know your judge, and are you looking at multiple counts or just a single count? Obviously, with multiple counts, very often those don't really matter for purposes of sentencing, but they do increase the theoretical maximum exposure of your client. So there are many things to meaningfully consider before throwing out the trial option. And one of the things that Fred and I wrote in our article is that we think that at least in white collar cases, that more and more people really need to start going to trial. And because if they're worried, and there's reasons, there's financial reasons and whatnot. There are many reasons why you would decide not to go to trial. But if it's because of the trial penalty, it's not as big as you think in white collar cases, and it may not be as big as you think in in other cases too. So the other thing to consider agreement is, are there material suppression issues? Maybe you have a really good Fourth Amendment issue there. Think about a conditional plea. Okay, I'm going to plead guilty, but I'm going to preserve this particular issue, this Fourth Amendment issue, and maybe I'll win that on appeal. So you don't have to give everything up that we see so often in plea agreements. It's just waiving everything, giving everything up, and there's the client at the end of the day isn't getting anything for that plea.
And how
And
many
so
pleas have we seen where it's like, there's really no agreements, but we'll recommend 3 levels
yeah,
for acceptance of responsibility. Well, you get that anyway. When you
right,
plead guilty,
right,
that's pretty
right,
fucking easy. And so
exactly.
this is all a cost benefit analysis. What am I
Yeah,
getting for this?
right.
And the biggest thing that's killing us, I think, well, you tell me, but it's there's almost always a waiver of appeal, which is to
Yes,
say except under the most limited, circumstances. Once you plead guilty, whatever the judge gives you, you're going to live with
you're
that.
stuck with it.
You're
Yeah,
stuck with it, and your
yeah.
your options would be. We literally had a case where a week after they were sentenced, or 2 weeks after they were sentenced, the Supreme Court issued a case that basically said what this guy pled guilty to wasn't a crime anymore.
Right,
And
right.
the Court of Appeals said, well, yeah, but you waived that.
Yeah, you
Yeah,
waived your right to
but did
appeal.
you
So
did you hear the innocent part?
yeah,
Well, there
right.
was an appeal waiver.
Yeah,
And I guess my question for you is how have we been conditioned to be like so complacent about it, the appeal waiver? Like, and I'm guilty of this too. Why didn't I ever just say, you know what? I like this plea. I want to plead guilty. I don't want to have to put you through a trial. I want to get the benefits of it. But I don't think it's fair that you're making me
yeah,
waive my appeal rights, because there's
yeah,
so many things that can
right.
go sideways at sentencing that I will not accept an appeal waiver. So you have a
Yeah,
choice, government. Do you want to live and die on an appeal waiver, or do you want to do this plea without the appeal waiver? And I
yeah.
don't know. I don't know if I've ever even gone to the mat over that, but I think that we, should start.
Right,
I think we should
right.
really
I think
give
we
that a
should
shot.
start, but I think where that's headed to, Doug, is a lot of these standard waivers now that we see, appellate waiver, any collateral attack on the sentence or conviction, that's waived too. All these stipulations that they'll have in there to how the guidelines operate and blah 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 blah. All those, if you push back on any of them, they'll just say, well, then go to trial.
Yeah,
But there are other options
but you
than
don't
going to
have to go
trial
to
or
trial.
exactly. There are other options.
Yeah, we'll
Um,
talk about that.
we're
The
going to talk about
dreaded,
that here in a second.
that's for some reason something that a lot of lawyers are super scared to do, is
And I'll show you why you should be scared.
plead
So
guilty without an agreement, but we'll get
yeah,
there.
so anyway, another thing to think about in the plea agreement is like what the issue here with Maxwell.
Yeah.
And this is very important. If the offense conduct extends across other districts. We see this a lot in high loss cases where there's a fraud that has occurred in, let's say, Florida and New Jersey and elsewhere, and just as an example. So though, those kind of, any type of plea agreement should, you at least should try to get it so other districts cannot prosecute this individual too. It's one and done.
And if I haven't mentioned, for those of you listening just on the audio, there's cool visuals coming up. So you better
Yeah.
head to the YouTubes. We have some charts. We have some famous sentencingstats.com charts and graphs and things for you to
Yeah.
look at. So what's next on here?
So what's next? So the next big thing to ask after you determine, what the trial penalty is will this agreement significantly reduce my client's exposure? And by that I mean, what is the client going to ultimately get out of this agreement that he or she otherwise wouldn't get by either pleading open, which we'll talk about in a minute, or going to trial?
Yeah,
I mean,
that's the certainty factor.
Yeah,
you plead guilty because you have some certainty about what is the worst case scenario.
Exactly, and really that you're expecting to get a lower sentence than had you gone to trial. And a lot of these plea agreements don't guarantee that. So if there's no guarantee that speaking of the certainty, that I'm going to get a lower sentence by pleading guilty than going to trial, then what am I getting out of this? Probably nothing, nothing in the grand scheme of things. So some things to think about is, like, if you're looking at a conspiracy or some type of fraud conspiracy case, get the government to potentially plead your guy to one count of 371. That caps them at 5 years. So under no way could he get more than 5-year term. I mean, that's just an example. You might not always be able to negotiate that, but also removing any mandatory minimums. Let's say that he was charged with a 924C, which is, you see those in the gun cases. Those are consecutive sentences depending upon possessing, branding, or discharging. Or the 1028A, that's the aggravated identity theft. You see those primarily in fraud cases that carries a 2-year consecutive sentence. You could try to negotiate those away. That reduces the your client's exposure. So is the plea agreement going to do that? Take those, and so if the plea agreement just takes your client from 10 counts of fraud to 5 counts of fraud, that's really not a significant reduction.
All coming in under the guidelines anyway, and your guidelines.
It's all going to come in under the guidelines anyway.
Through the roof. Now, not for nothing, but this is redundant. This is kind of what I just said earlier. But here's the thing: because of the policies of this DOJ to charge the most serious offenses and even to plead to some of the most serious offenses, this is not going to be easy to convince the government to give you a 371 count with a 5-year cap or whatever. But that is why you have to sort of pull out all the stops in developing not only your case narrative based on the offense, but your overarching narrative. You got to put it all on the table in plea negotiations to say, this is why, this is because they're going to have to probably run this up the chain, and they're going to need to have something to base this on. You don't just get to say, hey, what if we do this? No. Okay. I mean, we see that all the time. The government said no. What am I going to do? Well, what have you done? That's the real question. What have you done? And a lot of lawyers don't understand, or they don't have the work ethic, I guess, to put in the work to, draft a 20-page document settlement memo that shows them all the reasons why what you're asking for is absolutely reasonable.
Right.
But you don't get to just sit around and say, hey, I think you should do this. And then they say no. And you go, well, we asked, but the government said no. Of course they said no.
Yeah,
they're guaranteed to say no.
Yeah, you have to provide them with something. You have to provide them with a reason to say yes, not just your good looks.
Right. So.
And then there's always, if you can't get the government to agree on all reducing the stat max, or reducing the mandatory minimum, or anything like that, or stipulating to favorable guidelines, fine. You can have all these guys. How much time do you want my guy to do at the end of the day? Well, 20 months, 24 months. Let's just enter into a binding C plea then, and forget about all this stuff about the guidelines. So you guys could have all the guidelines, because binding C plea, then it doesn't matter.
And
sometime,
for people who don't know what you're talking about,
so this
it's
is,
a
here, go ahead.
stipulated plea that the parties, the government and the defense, are bound to. The judge is not bound to. If the judge ultimately thinks it's not right or doesn't agree, they can reject the plea. But the difference is between binding and non-binding is if the judge rejects, you can withdraw your plea and go to trial. All your rights are restored. Under a non-binding plea, which is what we see more often than not, if the judge can say, well, that's a nice recommendation that you made, or suggestion, but I don't want to do it. I'm gonna sentence you to 20 years. There's nothing you can do
Right,
about it.
right,
Yeah. We
right,
don't see enough C pleas.
right.
And here's where you've come in like very handy, because sometimes we'll work with lawyers in a certain jurisdiction and they'll go, "Wow, they just don't do C pleas in our district." And and
Well, I
then
can tell you if they do or not. I can tell
yeah,
you which cases.
and you've gone in and you've done
Yeah,
whatever little
the
geek
magic.
magic you do,
Yes, yeah,
and you're like, well, yes, there are plenty of sea pleas, and I don't know what you're
correct.
talking about.
Yeah.
And it's just so yeah, okay. So, but at
So,
the end of the day, if the government's not going to play ball, you have another option, which is
and the
just
final option is,
yeah,
and this would, this is where really, I wish we'd see more of this. Plead open, and
yeah,
pleading open or pleading straight up, as sometimes it's called, is you just plead straight up to the indictment.
right,
And so let's say you're looking, at 10 counts of wire fraud, and the government is coming back and saying, look, we'll dismiss 9 and we'll plead your guy to 1, but we want him to stipulate to, $9 million in fraud and all this other stuff, and $9 million in loss,
hmm,
and he's going to end up getting close to the 20
right.
years anyway.
We're not going to
Then you might as
agree.
well,
We're not going to stipulate that he's not a leader or organizer.
yeah, yeah,
We're
and
not
we're
going to
gonna fight. We're gonna fight
stipulate
you
that.
on a whole bunch of
Yeah,
stuff.
yeah,
He's not a 0 point offender and doesn't qualify for. Then you might as well just plead open, because even with those 10 other counts, they're all going to be grouped together, and even if they're not grouped, unless there's a mandatory minimum that the government is going to pull, you're not, your guy isn't getting anything, or unless it's like a binding C plea to a period of time that your guy's happy with.
yeah,
Unless it's that, then you might as well just plead
yeah,
straight up to the indictment,
yeah.
because your guy's going to end up, and I have the stats. I'm not making this bullshit. This is a bullshit. We're going to
Yep.
see the pretty charts in a
Yeah.
second. He's going to most likely get pretty much the same thing as he would have had he pled to that agreement anyway. Except now, what's the benefit of pleading straight up or open to the indictment? Now you have your right to appeal all of the sentencing issues, how the court calculated the guidelines, the substantive reasonableness of the sentence, the restitution amount, etc. All of that. You could
Yeah.
collaterally attack if the Supreme Court 2 weeks after you've pled guilty says, "Hey, you know what you did is not a
It's not.
crime." Well, guess
Oh,
what? You
good.
can appeal
Thank
that. Say,
goodness.
"Look, I didn't do it. I didn't do it
Yeah.
wrong. Sorry." You know,
Well, the
um,
benefit is you
and you
just
still get acceptance of responsibility.
yes, because you're admitting to the but before you even get to the appeal part, I mean, a lot of this is you get to argue it at the sentencing. In other words,
Right.
a lot of times they're going to say you're going to stipulate loss is 10 million. Well, I don't think loss is 10 million. We're going to
Yeah.
fight about that.
Right.
And a lot of times you can basically turn a sentencing hearing into a mini trial with
Right.
experts and all the things that you would do to prove this, that, and the other. But we
Right.
roll over so much. Well, I mean, you and I know this
Yeah.
because we work with lawyers all over the country, that a lot of lawyers are really skittish about this. They're like, I don't know. I don't. We've even had one lawyer go, there's no fucking way I'm doing this. And first of all, it's not your decision, lawyer, it's a client's. But
Right.
my question to you,
Yeah.
why do you think lawyers are so fearful about pleading open to the whole indictment?
Because it makes them feel exposed, that they are getting a false sense of security and a false sense of certainty from these bullshit plea agreements that the government jams down their throat. And forgive me for saying this, but a lot of lawyers that we know, they practice in front of the same court their entire career, and it's the same judges, the same 2 or 3 judges, and the same 3 or 4 prosecutors.
Yeah.
And so it kind of be this is just human nature. you start processing everything the same way. You and I, we're all over the place. So we see how it's done differently in so many different districts and different types of plea agreements and
Yeah.
different attorneys negotiating different things. And so we can be very eclectic and bring all of that's the specialized experience down to a
Yeah.
particular issue. So at any rate,
Yeah.
to answer your question, I just think it's just employment inertia.
Yeah.
This is the only way I've done it, and what I'm about to show you is pleading open is I guess the unsung hero
Yeah.
of a federal sentencing, that it really should be taken advantage of much more frequently
Yeah.
than entering into these shitty plea agreements. I had one public defender tell me once that he would never ever unless it involved the removal of a significant like mandatory minimum like a 924C or something like that, or consecutive sentence, unless it involves something like that, or his client at 371. Other than those two, never enter into a plea agreement offered by the government, because at best all it does is save your client a few $100s on that special assessment. And
Yeah.
what he's talking about is defendants have to pay a $100 special assessment for every count of conviction. So if you have 10 counts of wire
Yeah.
fraud, your client's going to owe $1,000. But if
Yeah.
it's only 5 because of the plea agreement to specify, he saved $500. But that's
Yeah.
all he's saving,
Right.
and he's going to go to prison for 20 years
Yeah.
with no right to appeal. So
Yeah.
that's absurd.
Well, and we'll go to the stats because we've had lawyers say, "Oh, that never is gonna be go well in my district. I've never seen a straight up plea go better than a regular plea," and the stats don't seem to bear that out, right?
So let's look at this. So what we're looking at here, this is comparing, and these are just averages, by the way. These are
Uh-huh.
just averages.
Okay.
So, and this covers every single. This covers basically almost 700,000, over 700 sentencings since Booker for the last 20 years. Everybody except the 2L cases. The 2L cases are your immigration cases. I took those out because those are a special breed. A lot
Yeah.
of them have
Fast track,
fast track, and so
significant
they're treated
departures.
they're treated differently. They have very low
What you're saying
sentencings
is they
already.
fuck up your stats.
They fuck up the stats
Yeah.
artificially, so that's why I took
Artificially.
them out. So this is
But not for
everybody.
nothing. This is
Yeah.
615,577 plea agreements, and of those, almost 100,000, 1/6 of them were straight up pleas.
Well, that's an
That's
additional. That's not
oh
the open straight up plea. That's
oh okay.
additional. So
But
that's so
still,
what
the
we're
fact
comparing.
that there's almost 100,000 straight up
Yeah,
pleas, that seems like a pretty significant number.
yeah, yeah.
And
It
that
is. It
tells
is.
you that
It
a
is.
lot of people have caught on to this,
Yeah.
that this is a racket
Well,
that the government is perpetuating in a lot of cases,
yes.
and that
Yeah.
you
A
don't
lot of
need to
people.
play
So,
that
but it
game.
varies. So, I mean, this is really from 100,000 foot level. The amount or the ratio of open pleas to plea agreements, those change from offense type to district, of course. There's
Yeah.
different practices in different districts and all this other stuff. But anyway, so without getting into all those little nuances here, just looking from 100,000 foot level, what this is comparing are and it's by offense level. So this is kind of nuanced. And I started at offense level 13, which is in zone D. This is the zones of imprisonment, where basically the guidelines say that you have to do some time of imprisonment, even though we know that the guidelines are advisory. At any rate, I started the analysis here just starts at 13 because it's kind of meaningless at lower levels, all the way up to 43, which is your highest offense level under the guidelines. And so I compare by offense level everybody that pled guilty at that offense level, what was their average sentence, versus that pled guilty pursuant to a plea agreement, what was their average sentence, versus those that pled open that had that exact same offense level. So, for example, at offense level 15, those who pled to a plea agreement, 21.3 months, but waive right to appeal, they're stuck with that. That's just
Mhm.
on average. Versus if they pled straight up, it was 25.8 months, a little bit higher, but They
Yeah.
have a right to appeal. They've preserved all these issues. So a lot of these
Right.
sentences may have gone away because they may have been reversed, vacated, lowered, resentenced, et cetera, et cetera, et cetera. And they're able to collaterally attack them and all this other stuff. Or
I'm
they didn't
very
have to,
disappointed that your charts don't reflect how many of those cases went away from appeal or something.
unfortunately, the commission doesn't collect that data, but that's
I'm
that would
just
be great.
teasing you. But
Yeah.
you're talking about
So,
4 month, essentially 4 month difference.
yeah, a 4 month
That
difference.
seems like a pretty small sort of delta given the rights that you retain, even though it's not easy to
Well,
do.
even but what's really interesting, I don't have the exact number here, but if you look at offense level 34, which is pretty significant, that's way up there.
Hmm.
The as you can see, for those of you who are listening, if you watch the YouTube, you will see that the average sentence is actually higher for those that plead guilty than those that plead straight up. And that's at offense level 34, or at offense level
Wow.
28, they're pretty much the same.
Wow. Yeah.
Same.
Wow.
So, the biggest delta may be up here at offense level 40,
Yeah.
and the average sentence is 260 months by if they pled guilty pursuant to an agreement versus 281 months or 282 months
Yeah.
rounding up if they pled straight up. So the
20,
difference there is about 22
20.
months. But remember, I mean, you're already doing a shit ton of time if you're pleading to an agreement, and now you've
Yeah.
waived your right to appeal. Whereas that extra 22 months, you still have your right to appeal,
Right.
and you can litigate everything. And some of these people may have resulted in reduced sentences.
Yeah,
So
and
the
couple of things. The more you work your case, the more likely you are to get a really favorable plea with lots of certainty and lots of carved in stone stipulations. So, who knows? The more that lawyers start saying, you know what, I'm not interested in your plea. We'll just plead straight up, and we're going to litigate every single issue. And we're going to turn every single sentencing into a mini trial. Prosecutors might get a little tired of that, and they might say, I really don't want to have a 2 day hearing about loss, or I don't want to, and maybe they're going to give you a better plea. I mean, that's a thing. The more you make your case, the better your plea is going to be. And I will say this
but
too.
we all have to do it. That's the
Well,
thing.
yeah, we do, we
Yeah,
do, we
we
do, we
all
do.
have to do it.
But
Yeah,
and
that.
here's the other thing. The lawyer, I think some of the fear, you raised some legit concerns about why,
Yeah,
well, I don't know if they're legit, but you've raised some true concerns about why
yeah,
lawyers are afraid to do this. I think there's another sort of fallacy of the fear, which is to say, I'm worried that if I don't bow down to the government and take whatever shitty plea they're offering, that I'm
mhm,
telegraphing to the judge that I'm not really sorry, or I'm not really accepting responsibility. And if I'm fighting about this issue, that issue, the judge is going to be really mad at me.
yeah,
And I, this is the same. Listen, it's the same analysis you have for whether you're going to ask for, bottom of the guideline sentence versus probation. Lawyers don't want to make an ask that's going to make them seem not credible or take them out of the
right,
conversation, right?
right,
So it's a good instinct for a
yeah,
lawyer to say, I don't want to do anything that's going to piss the judge off, right?
right,
And they think this open plea is going to piss the judge off. And if you have basically, you know, if you had like if you could actually go before the judge and say, Your Honor, my client has always accepted responsibility. He's always wanted to plead guilty. He's always wanted to make this right. But at the end of the day, we presented all this to the prosecution,
right,
and they weren't going to hear it. And they
right,
weren't going to offer us a plea that we thought was reasonable. And we
right.
trust you, Your Honor, because
Bingo.
ultimately it's your decision. And
Right.
this is what we need you to know to make the right decision in the case. And you
Yeah,
may or may not get the result you want, but at least you've said to the judge, my client's all on board with playing the game and pleading guilty and accepting responsibility, but he has legitimate reasons to want to have you dig a little deeper into this. And I
eh,
think if you've done your homework and you
yeah,
can make your case, even if the judge doesn't agree at the end of the day about whatever issue you're fighting about, at least she understands that you had a reason for pleading straight up. You weren't just trying to be an asshole, right?
That's correct. And the fact of the matter is the way a lot of these agreements are written, there's going to be the same amount of litigation over the same amount of issues anyway. We see this a lot in cases where loss is not determined. As a matter of fact, I've been seeing a lot more plea agreements now where there's no stipulation to the guidelines at all. The parties are free to argue whatever sentence they want, and however the guidelines, they think the guidelines should apply. So all of that needs to be litigated anyway. You're not saving the judge any time in any decision making by pleading guilty to the agreement versus pleading open.
Yeah.
The judge is going to be presented with the same evidence and the same arguments either way. The only difference is your client will have the ability to appeal whatever if you plead open, whatever the judge does.
Yeah.
And that, and one thing is, I remember when I was at the commission 100 years ago, the waiver of appeals was somewhat new. It really started hitting its stride like in the mid 90s, and I was at the commission in the early 2000s. But I remember there was a lot of chatter at the time, a lot of talk, a lot of concern about these appellate waivers that DOJ was having. And the reason why is because it was precluding development of case law. Yeah. Because there was a lot of, and we would see this. I mean, I would see this personally because sometimes I had to code and do some data intake. That's why I'm the data nerd guy. I know the data really well because I had to deal with the data and do the data intake and looking at all these pleas and PSRs and all the stuff, thousands of them. And you could see a lot of mistakes that were being made by judges, by the parties. And those were reviewable because the appeal had been waived. A lot of what we would call at the commission illegal sentences because they did not comply with the guidelines. But there was nothing anybody could do about that in light of the appellate waiver. Right. So it really, I hate to use this word, but I mean this literal sense. It retarded the development and the evolution of really good, robust sentencing law as a result of these appellate waivers. So that's one thing I think like NACDL and other institutions really need to start voicing again is the concerns, and maybe with the federal judiciary itself, about the ethics of requiring appellate waivers.
Right.
Because appellate courts need to, their job is to police the district courts, and they can't do that with these appellate waivers that are routinely implemented. So, you're helping the development of case law, not only your client, but the development of case law by pleading open.
Well, yes, I'm with you 100%. But I think here's the underlying sort of, problem, tension, dysfunction. This is a broken system. And there's a reason why 96% of cases never go to trial. And it's not necessarily because everyone's guilty and they're getting great deals. It's because the system is designed to prevent you from going to trial, to scare you into saying, if you go to trial, you're going to get hammered at trial. So you better plead guilty. So this is a coercive, coercive, so much so that innocent people are coerced to plead guilty. We see this time and time again. Because the truth is, if every single defendant exercised their right to trial, the system would collapse on itself. And in the same way, that's why they do appeal waivers, I believe, because if every defendant who is convicted of trial or pleads guilty has the right to file an appeal, the appeal system collapses on itself. And this system is set up to process everyone through as quickly as possible, get them off to prison, and never hear from them again. It's a meat grinder system. And I would say maybe part of our job, part of our responsibility is to slow that down, maybe take a closer look at how we're doing these things.
More trials, more open pleas.
More trials, absolutely. More trials, more open pleas, because your stats tell us that it's all it's all a cost benefit analysis at the end of the day. And I always say, if we had one thing, if I could ever have as a criminal defense lawyer, it's a crystal ball, so I could tell you exactly what the outcome is going to be. I don't have it, but the next best thing,
I have some close.
That's what I'm saying. The next best thing are these stats, because you can
Right.
see how it all plays out in other
Right.
cases and
Right.
extrapolate how it may play out in your case. And I will say
Mm,
one story that we just had in a case, which is I had a client. I wouldn't say he dressed me down, but he said, I need you to know something for your future clients, just
mm,
so you know. He said, I brought you and Allenbaugh into this case to assist local counsel because you are the sentencing specialists. This is what you do.
mm,
And we had a situation where we thought the government was in breach of the plea agreement and we
mm.
wanted to blow it up and get out of the plea, meaning
Yep.
probably plead straight up and not be bound by it.
Right.
And at the end of the day, the local council who knew the local landscape said, guys, slow your roll. I know this judge. I think, he's kind of bloviating about what he's talking about here. I'm not that worried. At the end of the day, you're going to be better off staying with the plea. And we, rightly or wrongly, we deferred to local council because they know more about the local landscape than we do. And things went badly.
Yep.
And in hindsight, which obviously is 2020, the
Mm.
client was like, next time stand your ground because you know better. And don't be don't fall for that same sort of story about I just, we got to play ball, we got to go along, it's going to be okay.
Yep. Yep.
Because a lot of times it's just not okay.
Going along to get along does not work in federal court. Not at this level.
All right, that's the end of part 1 of the episode we're calling Maxwell's Silver Hammer. So I'm going to bid you adieu for now, but don't forget to come back for the next thrilling episode of Set for Sentencing, where we're going to keep going with Ghislaine Maxwell and her silver hammer. And who knows, I may even have some additional updates for you by then, because this case is everywhere all at once and not going away. See you next time. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.